But the headline is the holistic process of admissions remains valid. There's going to be some redrawing of the rules that I think everyone has to observe and let happen that will probably vary from region to region, will probably be subject to litigation.
Thanks for tuning in to Keep It Legal, the show where we break down concepts, litigation, and current events with our legal experts. I'm your host, Mark Anik. Joining us today is David Bissinger of Bissinger, Oshman, Williams, and Strasburger, LLP, or Bose Law in Houston. Dave, it's great to have you with us.
Thank you, Mark. Great to be here.
Do me a favor, both for me and for our audience. Tell us a little bit about who you are and what sort of law practice you have.
Well, I'm a lawyer. I've been practicing in Houston for just under 30 years, and I practice in a variety of complex commercial litigation, investigations, and arbitration settings. I, for example, handle a lot of cases arising out of the broker-dealer and investment advisory world. Largely, those are arbitrations or investigations handled by the Securities and Exchange Commission or FINRA, the Financial Industry Regulatory Authority. Second, I do a lot of work involving trade secrets and employee covenants for both plaintiffs and defendants, largely in the energy industry. Third, I've been handling some matters arising out of Winter Storm Uri involving the Texas power grid. And that expertise also dates back to my securities litigation experience years ago with matters arising out of Enron, Dynegy, Reliant, and other players during that sort of Enron meltdown that hit so many other energy merchants. We also do a lot of just commercial litigation involving the energy industry, supply contracts, for example, other contract disputes, things that sometimes have a high degree of technical material that needs to be simplified. Those cases find their way to us. And then I think we've also done a lot of real estate litigation, which is sort of related to the securities litigation world because of the financial component, and especially so much real estate litigation that occurred during the credit crisis of 2007, 8, and 9. And then, from there, it just can vary. But that covers, I would say, probably about 80% of what I do, fairly representative of the rest of my firm.
You mentioned Enron and Dynegy, and you're in Houston, I'm in Dallas. You say those names in Texas, and obviously worldwide, but especially in Texas, people recognize them right away. What sort of role did you have in those cases?
The most significant role was defending the former CFO, chief financial officer of Dynegy. After Enron filed for bankruptcy in 2001, a series of investigations occurred, and one of those involved a Wall Street Journal article that was published, I believe, in early 2002 relating to a Dynegy transaction. And around the time of that, shortly after that publication, the CFO of that of Dynegy retained my partner, Mike Wilson, and me in probably 5 or 6 separate matters. A class action, what we call a 10b5 class action here in Houston that Judge Sim Lake presided over. 2 separate ERISA class actions over which Judge Lake presided, I believe in both. An SEC investigation, sort of tangentially a criminal investigation, a Department of Labor investigation, a federal derivative case, a state derivative case, and then I think a couple of other matters in which Rob was a witness. So it was sort of a huge smorgasbord of securities and energy litigation issues. It touched on other areas as well.
What is something about Dave Bissinger that I would not know from listening to what you've just explained to me or reading your online bio?
Well, things that are interesting is I have 4 boys. They are 23, 21, 19, and 16. Married to the same woman, my wife Meg, for nearly 30 years. Strong family. We really enjoy each other very much, but I guess we don't probably publicize it the way maybe other folks might on their websites and that sort of thing.
Okay. 4 boys. So you're going to be working for a long time if the younger two are 19 and 16.
Yes, that's okay. Yeah, and I have friends that are retiring now, and a couple who've already retired, and I just can't imagine doing that. There's too much I want to do, and too many cases in which I'm involved. I want to see what happens.
Okay. We wanted to sit down and chat with you today. The topic du jour is affirmative action and the Supreme Court's June decision that got an awful lot of coverage, obviously, and continues to be talked about because people now are trying to figure out, okay, what sort of implications does it have as we move forward? But I want to go backward first to the 1990s because you worked on a case involving the Lanier Middle School in Houston. Can you tell us about that?
Yeah, sure. I think in 1996 and 97, I was at the firm Weil Gotshal and Manges in its Houston office. Just down the hall from me was a lawyer named Greg Coleman. Greg was an extraordinarily talented lawyer, and so it was fun to sort of be in Greg's orbit because he really was a superstar, super smart, just a wonderful person. Really fun to work with, and he had a relationship with Edward Bloom, who was at the time and continues to be, I think, if not the leader, certainly among the top leaders in the world of challenging race-based classifications in higher education and elsewhere.
So in that case, what was the crux of that case at the middle school?
It was that the Vanguard program, which was a gifted and talented program at the Lanier Middle School, was using race-based classifications in admitting students and putting a heavy emphasis on race as a factor for admission into those programs.
Okay. And ultimately, what happened there?
Ultimately, the case settled with Houston Independent School District, represented by Kelly Farrells, who was really another just distinguished, phenomenal lawyer representing HISD and the Vanguard and Lanier Middle School, in essentially a consent decree that largely ameliorated the prior use of race in that program.
Okay. You and Mr. Bloom, I believe, also worked together on the case involving Abigail Fisher and the University of Texas.
Very, very briefly, I am not a Supreme Court advocate, and he has a large number of people who do routinely handle federal appeals in general and Supreme Court advocacy in particular. But there were some limited things in the Houston area that I assisted with back nearly 15 years ago or even more.
And what did Fisher, ultimately that case made it to the United States Supreme Court, and what ultimately was the outcome of that case?
The Supreme Court essentially affirmed Grutter versus Bollinger, which was the case that Students for Fair Admissions against Harvard and University of North Carolina has since overruled. In the context that the use of race at the University of Texas, according to the court, in that context, was not violative of the Equal Protection Clause.
Okay. And you've mentioned the case from June of this year, which is Students for Fair Admissions versus the President Fellows of Harvard College. And there's a similar case against the University of North Carolina that the court decided 6-3, and in essence set aside those kinds of racial preferences that those schools were practicing, correct?
Yeah, in essence, with more than 230 pages in the opinion, there's much more to be said, of course.
Right. I want to read just a couple of portions of the opinions. The majority opinion written by Chief Justice Roberts. There's a line in here. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. People are focusing on that language now, schools and others, as they try to discern, okay, what exactly can we do? What's your view on this? If you were advising these schools, what does the opinion allow them to do and say that they can no longer do?
I think what they can no longer do, according to the opinion, is what I think both sides use the term check the box. In other words, if you're just using race as a factor in admissions without more, that's out the window. What the dissent argued was that it was already out the window. And then the majority essentially countered, saying, well, if it's out the window, then why do we still have these boxes? And so that paragraph that you read, you're right, is the focus of much of what everyone is focusing on, as are some similar paragraphs, by the way, in Justice Sotomayor's dissent about what can you do. I think the best way I would say it if it were a headline, the headline is the holistic process of admissions remains valid, and that it can include even a consideration of race in the context of a student, for example, that has encountered discrimination, other disadvantages tied to that student's race.
You're right. It's interesting. I was just reading a Times piece this morning about the manner in which the questions for essays have changed based on the June decision. Already, they were quoting a number of colleges and where there was one question before, and it might have been about your activities,
Right.
what jobs you worked, et cetera. Now there are questions asking about identity, life experience, things that shaped who you are.
Right.
That those potentially might give us a more well-rounded view of an individual.
Right. And I mean, when you look at like Justice Thomas's opinion, excuse me, not a dissent, but his concurring opinion, he makes clear that even the consideration of race, if it's narrowly tailored to that candidate's life experiences, can be permissible. It's the there will be instances in a lot of applications, presumably, that an applicant can speak to the specific hurdles that applicant has overcome to become eligible, even to apply, and therefore to be admitted, that are not outlawed. It's the use in constitutional law that if you deploy a criterion based on race, that it is subject to strict scrutiny, and that doesn't mean that it's out the window completely, and that there are going to be instances in where I think even according to Justice Thomas, that is that consideration of race can be permissible. But I think what both opinions spent some time on it. Both sides spent time on. There's more than one opinion, but is putting aside whether you want to get that close to it is when what is even, I think, a wider berth is given by the majority opinion for socioeconomic considerations. For example, students who are first-time college applicants and their family histories, students with other familial limitations, single-parent homes, poverty, other struggles that can, obviously vary. And that I think that in the admission process, more and more weight will be given to the essays, letters of recommendation, other qualitative materials that have already been developing, for decades, but especially since Grutter in 2002, because it was clear even by that point that universities needed to focus on as much as possible race neutral alternatives to simply, relying on checking the box. And what will happen, I think, to me is, on the one hand, maybe not as shocking if folks were to take the time to read all 230 plus pages of these opinions. But on the other hand, there is a sort of a newness to this that in a lot of ways reminds me of the recent Supreme Court opinion over NCAA limitations on name, image, and likeness, the NCAA versus Alston opinion, in the sense that in both contexts, you're dealing with a change in the way higher education is dealing with what people, I think my generation, I'm 55, had just taken for granted. On the one hand, athletes could not be paid at the college level. And on the other hand, race could be used as a plus factor ever since Bakke in 1978 for admissions. Both of those things are out the window. And in both instances, there's going to be some redrawing of the rules that I think everyone has to, observe and let happen, that will probably vary from region to region, will probably be subject to litigation, further litigation, and will continue to be the subject of, I think, debate and controversy and media attention, because education, especially at the high level, just like sports at the high level, you're dealing with, elite students vying for scarce slots. And how do you treat them? Do you, in athletes, do you pay them? Do all athletes get paid? Probably not. With students, how do you handle the race situation? It's going to have to be more qualitative now, and the reliance on simply race as a metric is now forbidden.
You mentioned Justice Sotomayor, and in the view of just a little bit of equal time, I read from Justice Roberts, so I wanted to read part of what Justice Sotomayor wrote. She said, "Today, this court stands in the way and rolls back decades of precedent and momentous progress. It holds that race can no longer be used in a limited way in college admissions to achieve such critical benefits. In so holding, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter." You mentioned that we're bound to see further litigation. When I read something such as that, it makes me think that you're probably correct in that regard.
And both sides had to deal with ambiguous precedent. And for example, to a large degree, the dissent relies on a very famous dissent in the case Plessy versus Ferguson. But yet, because Justice Harlan in Plessy versus Ferguson dissented from the separate but equal holding, allowing, generations of segregation. And Harlan said no, but a touchstone to Harlan's opinion was his statement that our Constitution is colorblind. Justice Sotomayor says, well, only in the context of, slavery and the history of racism in the U.S. did he say that. But nevertheless, that is the statement that, Justice Harlan, one of the statements he made, and in which the majority relies a great deal.
You mentioned Plessy. I know you read most, if not all, of the 237 pages of the decision. I'm well behind you in my reading, but as I read through it, I felt as if I were in social studies class all over again.
Right.
In middle school, there's mention of Plessy and Brown versus the Board of Education of Topeka and Bakke and Grutter, as you mentioned. It's interesting to me that these issues that we have debated for decades, for hundreds of years, continue to remain part of this lively experiment that we call America.
No, I consider this process, looking at it, if I were, say, teaching a high school civics class or college introduction to constitutional law, is a dialogue. I think we all have to embrace that. Now that we have this decision, the question is, I think, what next? What does it look like going forward? And again, I think the concessions that the SFFA, the petitioners, opposing the use of race as a factor, isolated factor, they made concessions in oral argument as well as their briefs about these other race neutral ways in which a diverse student body could be created through the admissions process. So we're not done with this by any stretch, and I think admissions departments and universities in general may retool their bureaucracies to focus on, for example, that very detailed admissions process, because it's going to become much more difficult. I mean, I think that if you go back to the Hopwood case, which is the Fifth Circuit case involving the University of Texas Law School from the mid-90s, that case laid out a system of admissions that even to this day still is in place to some extent. And that is that a school will focus on the academic credentials of the student, of the applicants, in terms of their SATs or LSATs in this case of law school, and then their grade point averages. And they, in Hopwood, for example, the University of Texas Law School created what they called the Texas Index that weighed, I think, LSATs, and forgive me, I forget the detail, but maybe about 60%, and grade point at about 40%, thereabouts. And for that Texas Index then created three buckets: presumptive admit, presumptive deny, and then a middle ground in which they spent more time examining the applications. And one thing that was very pronounced in Hopwood that has since been ameliorated was Hopwood was, very pronounced in the way they weighed race as a factor. And the Fifth Circuit prohibited that. And that's in part why we have a top 10% program here in Texas. That overall process is still in place. And I think for most people, it was, at least for a lot of people who read that opinion, it's eye-opening to realize that your grade point and your standardized test score is the main driver, in a way that I think sometimes is de-emphasized to high school students or college students applying to competitive law schools. And then the question is, when you have that, once you get beyond presumptive admit, presumptive deny, and you look at the qualitative review, this is just going to take more resources in that process.
You mentioned that we're not done with this by any means. And certainly in the context of, if you and I were running a college admissions department today, right, we would be sitting here trying to figure out, okay, what can we do? What are we prohibited for doing? How do we continue to move forward so that we have a very good and very diverse student body? It's also not over with regard to Mr. Bloom and his organization. I have an article from the Wall Street Journal where he has brought suit against two law firms and programs that they have that fall under the heading of DEI, diversity, equity, and inclusion. And I guess the question that I have is that I really wanted you and me to have an opportunity to talk about is, okay, so we've got that decision, and it's one that is specific to education, but it does have implications across the board for business. And I guess the first question I have is, if you're at one of those law firms that Mr. Bloom is targeting right now, what sort of advice would you provide?
Well, assuming they're willing to listen, but
I'm going to assume, Dave,
I,
that they're willing to listen. Yes.
yeah, is in the instance, for example, I have in front of me the complaint just filed August 22nd, 8 days ago, in American Alliance for Equal Rights versus Perkins Coie. That's filed in Dallas, and that lawsuit addresses a diversity fellowship for 1Ls and 2Ls that, at least according to the complaint, excludes students based on their skin color, according to that. And then, at least according to the opening paragraphs of the complaint, applicants do not qualify unless they are, quote, students of color, close quote, open quote, students who identify as LGBTQ plus, close quote, or open quote, students with disabilities, close quote. And so between two heterosexual non-disabled applicants, one black and one white, the latter cannot apply based solely on his race. And the lawsuit in that case is not a constitutional challenge. It's a lawsuit under section 1981 of the Civil Rights Act of 1866. So it's a little bit, it's different in the sense that it doesn't address the Equal Protection Clause as such. It is a civil rights claim that alleges that programs use discrimination in private employment on the basis of race, which the statute prohibits.
How do you think, whether it's a Perkins Coie, I think the other law firm was Morrison Forster, whether it's one of those law firms or it's any of the other businesses that you might represent, how do you advise and defend those corporations that are subject to such claims?
Well, I think in light of SFFA and the direction of the law in general, you want to avoid using race-based classifications to be the determinant of whether someone gets a job or admitted or another benefit. But you look toward race-neutral alternatives if your goal is to achieve diversity. And usually this is in the context of elite, prestigious programs, jobs, and that sort of thing. That if you think there's a value of diversity, that you achieve that diversity, which is, I think both sides agree. It's not just a question of racial diversity. There's gender diversity. There's diversity of perspectives, diversity of socioeconomic backgrounds, diversity of language, all sorts of different things that you look toward things besides just a naked use of race. And, one thing that came out in the oral arguments in FFFA to remind the audience is that even gender discrimination is subject to a lower standard of it's an intermediate standard, intermediate scrutiny versus race. Race presents these, both statutorily, but also constitutionally under the Equal Protection Clause, presents, thornier legal problems when you are dividing people along the racial characteristic. But if you use other means of trying to achieve diversity, those means are much more likely to succeed.
I want to play devil's advocate for just a moment, just for the sake of the discussion and not to pin anybody down. But I noticed that you and I are having this conversation. We're both Caucasian. We're both male. So this conversation is not diverse. We're similar in age. You're in your 50s. I'm in my 60s. I imagine if we had a gentleman or woman of color sitting at the table, they would look at us and say, all of this sounds very scholarly and appropriate, but it belies the fact that we're going backwards, that we're moving away from a system where we tried to address systemic racism in America. What would be your response to that?
Well, there's an assumption that you would be going backwards that I'm not even sure the dissent would fully agree with in SFFA. Clearly, in some respects, they wouldn't make that argument, but there were, the dissent went to great lengths, as did the universities themselves, both Harvard and UNC, to say that we've been making progress and we've been relying less and less on race. And they introduced evidence, for example, at the trial court that only like 1%, 1.2%, or a percentage, I think it was 1.2. It was in the one range, 1 point such and such range of decisions are actually based on race or attributable to race as the deciding factor. And other states, notably California, Michigan, and Florida, through either executive orders or statute, have eliminated racial classifications. And in many instances, they have not led to a regression of less diversity. In some instances, the universities argued that they had, but I think there's a real presumption that you're going backwards, because the whole point of Grutter, for example, was that Grutter said racial classifications are dangerous, and the swing vote essentially in Grutter was Justice Sandra Day O'Connor, who wrote the opinion, and huge amounts of time were spent on what she said in that opinion. But she said that racial classifications need to have an endpoint, a temporal endpoint,
25 years,
and anticipate. She said, I would anticipate that in 25 years they would no longer be necessary. And I mean, quite a bit of the oral arguments and the briefs and the opinions addressed what did she actually mean by that. But I think, the decision might have been different if Justice O'Connor had not been allowed to include that in the majority opinion in Grutter. She may have been on the other side, in which case you would not have had the holding in Grutter. And so, going back to Justice Harlan's dissent in Plessy versus Ferguson, where he says that, aspirationally, at the very least, and he doesn't say aspirationally, he says that our Constitution is colorblind, that, I think that is a huge discussion to say that we are absolutely going backwards.
We mentioned law firms as being a target of Mr. Bloom's efforts now. There's also a website that I found in reading an article from the New York Times. The website is westpointnotfair.org. And it appears that the military academies are perhaps the next target, or another target where you may have seen the schools practicing race-based admissions. How do you think they would fare? Are they going to be subject to the same standard post SFFA?
I think that may be a more difficult case, because Carter Phillips is, a famous Supreme Court advocate. He had filed an amicus brief on behalf of a group of, I believe, generals and admirals in the military, advocating for the use of racial classifications, because in the experience of the military, that those racial classifications had achieved, more tangible benefits than I think that the universities were able to argue in SFFA, although the university cited the evidence of the military as analogous authority.
You and I are in Texas. The governor this year, post the SFFA decision, signed, I believe, orders disbanding the DEI offices in state universities. What do you expect will happen in Texas and in other states when they make moves such as those, with no longer having a DEI presence as part of that process?
I don't know what the scope of those orders will be, in fact, because, given that the holding in SFFA allows for this holistic determination of applicants' merits that it can include socioeconomic background, and even in some instances with respect to race. Um, I think that to say that all of the efforts that you see in every DEI program are per se invalid, I don't think will work. I think every HR department in any big company and any employer, is going to have to be mindful of ensuring that there's no racial animus, discrimination against minorities. It's a lot like when you look at the debate over critical race theory, and people are either pro or against. And when you look at the materials that students study in those areas, they vary. And so I think, whether or not you're reading To Kill a Mockingbird or a Maya Angelou or something like that, is that going to be outlawed? I don't think so. Ultimately, I mean, a lot of Governor Abbott's opponents say that that's where he's going. Maybe, but I don't think that's ultimately going to happen. And I think, from my perspective as an employer, I mean, we absolutely value diversity as an employer, because when you go to try a case, you need to have perspectives. One reason I like working with younger people from all backgrounds is they see things that I don't. And the more perspectives you can have, the better within, your qualifications of, having people with sufficiently high grades and showing motivation, and people, do all the things that you want in your organization. So anyway, when it comes to the DEI programs, I just think that at some level they have to get aspects of them will get repackaged, because companies still get sued for violations of Title VII. Companies still get sued for sexual harassment, hostile work environment, that sort of thing. That law is still good law. And a lot of companies, have good programs where they teach people, look, this is appropriate, this is not appropriate. And so I just, I think there's still a role for guidance in HR departments, even if they are packaged in a different way.
And I find it very interesting that you mentioned that, because my sense is some people might see a decision such as this and think that rules that had been in place have been removed across the board. And your comment is saying not true at all with regard to race, with regard to gender, with regard to sexual harassment in the workplace. Good corporations need to be careful that they don't misinterpret any of this, right?
Well, and I think in general, they won't. You are going to have good employment lawyers that remind people, here you have Section 1981 that it applies to governmental and non-governmental actors, and that it allows a cause of action against discrimination in private employment on the basis of race. And that does happen, against minority groups from time to time by companies, and lawsuits get filed pretty routinely.
Dave, any advice for people who are interested in some of these issues and would like to perhaps learn more about them?
I would urge folks, to the extent they're really interested in it, not only reading the opinions, which is quite a Herculean task, but to going to the OYE website that has the oral arguments, and you can listen to the questions from the justices and the arguments from the advocates. And I have found, not just in the area of affirmative action, but in all sorts of areas of the law, that those oral arguments can really give you a humanizing context for understanding the issues that, sometimes when you pick up a brief, or you're trying to read a PDF on an iPhone or an iPad, is harder to do. And that, let me tell you, that's in my, for guys like us, Mark, that are in their 50s or 60s, that's new. I mean, I remember in the mid 90s when the Supreme Court finally let someone publish or, I guess publish or release cassette tapes of major arguments over the years, because they've been recording these, I think, since the 1950s or 60s, but they were not widely available. Now they're widely available. And not only are they available, but the OEA website tracks the oral recording with a written transcript, electronic, and you can follow them, and you can highlight or take a picture, and really get a flavor of the nuances here. Because I just think, like so many other issues, when you sit down and people reason together on this, they're going to disagree, but the disagreements are less pointed perhaps, and at least as a practicing lawyer giving advice to clients, you find that those arguments and statements from the justices give you a certain amount of humanizing context that is far more useful than just reading headlines from news organizations that have one agenda or the other, that are trying to sell papers, get clicks. And they're very approachable. Those recordings are very, very approachable. I encourage, I had one of my sons was taking an AP government class. I really encouraged him to listen to those. Lawyers I work with, if we're like in a patent case or securities case, go listen to a couple of these arguments. You really get a nice feeling about how the justices look at different areas of the law. That is a gift that is to me, I'm still amazed by it, because I had to go to law school and practice for several years without having that benefit.
Well, and no matter your role, right? Whether you're a student or an attorney or a business person, I think having the access to hear the justices, to hear the lawyers making their case in front of the court, those kinds of things are very powerful in a democracy. They give you and me the opportunity to, in effect, sit there and listen as if we were on one of the benches at the court.
Yeah. And I also highly recommend, in other cases, the YouTube channels for the Texas Supreme Court and the Intermediate Courts of Appeals. They're fantastic. They're video. And for a lot of us, oral argument in an appellate case is a rare event. And it's really great to see, whether it's a contract case or a case involving social issues, you see how these justices really wrestle with issues.
While I've got you, you mentioned Grutter. You and I spoke about it a couple of times, and you mentioned Justice O'Connor. Complete hypothetical. Any thoughts as to what Justice O'Connor would think of this latest decision in the realm of affirmative action?
Let me preface that by saying she was a famous moderate, as was Justice Kennedy. And so I don't want to say this in a, sort of a cynical way, but the moderates of the court tended to surprise you on different issues. And I guess still do. And, but I think thinking back then with O'Connor and Kennedy, that it is easy for me to envision her coming out on either side. And, for example, there's a paragraph in Sotomayor's dissent that is very similar to Chief Justice Roberts' paragraph, or maybe in both instances, maybe there are 2 or 3 paragraphs, but, where they say, they basically try to say, going forward, here's what we think is going to happen. And so it's easy to see Justice O'Connor falling in with either of those sides, maybe depending on how the opinions had come out. Another point that I think is really relevant is when you go back to the original decision in this, well, not the original, because there were a couple others, but Bakke versus Regents of California in 1978, which was a plurality opinion. And somewhat oddly, but Justice Powell, who was also one of the moderates and swing votes, had a lone concurrence that ended up becoming the law of the land. I think you could probably have a lot of fun coming up with multiple, like, endings, like the Scooby-Doo ending, or the other, the Love Conquers All ending. I mean, you could come up with probably 3 or 4 different versions of SFFA with O'Connor, if, tweaking things here and there a bit. I guess I tend to think that she might have ruled with the majority here. But it was a 6-3 decision. Would she have wanted to make this a 7-2 decision? Maybe she wouldn't have.
Dave, thank you very much for joining us.
My pleasure. Mark, thank you.
That was David Bissinger of Bissinger, Oshman, Williams, and Strasburger, LLP, or Bose Law in Houston. You can visit bowslaw.com for more information about the firm. That's bowslaw.com. Make sure to like us on Facebook, subscribe to us on YouTube, and tune in next time to Keep It Legal. I'm your host, Mark Anik. We'll see you then.